Is sex part of your lawsuit? And you might be thinking, wait a second, what do you mean is sex part of your lawsuit? You want to know what this question is about and why it can affect you? Come join me on this walk along the beach as I share with you the answer to this question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is yes, it could be. Now, I should clarify. When I say is sex part of your lawsuit, in many instances, the injuries that you suffer as a result of someone's carelessness, whether it's from an accident, whether it's from medical malpractice, now, if you are married, and now your injuries have affected your relationship with your spouse, and now your ability to have sexual relations with your spouse has become affected, then yes, now it is possible to include your inability to have sexual relations with your spouse as a claim, as a part of the damages that you are seeking for all the harms and losses and damages that you incurred because of someone else's carelessness. So now, when I ask the question in the title of the video, is sex included in your lawsuit? No, just because you file a lawsuit doesn't mean you get to have sex. It doesn't mean you're entitled to sex. It doesn't mean any of that. It means that if your injuries have affected your ability to have relations with your spouse, yes, now you can include a claim that you can no longer have sexual relations or your ability to have them has been significantly impaired. Now, what does this really mean? I'll tell you what it really means. It means that during the course of your lawsuit, there will be a time where the opposing attorney or attorneys will have a chance to question you in a process known as a pretrial deposition. That's a question and answer session that typically in pre-COVID times would take place in your attorney's office. During COVID times, it takes place typically on a Zoom video call. During this pretrial question and answer process, you are going to be on the call, your attorney will be on the call, the defense lawyers will be on the call, and importantly, a court stenographer will be there to record all of the questions that you are asked and all of the answers that you give. The answers that you give represent your sworn testimony, and in case you don't know, it carries the same exact weight as if you are testifying at the time of trial in court in front of a judge and in front of a jury. Okay, so what does all this have to do with whether or not you can have sex as a result of the injuries you suffered? I'll tell you what it has to do with. The defense lawyers, in trying to learn the extent of your injuries and how you have been damaged because of their client's carelessness, they will have a chance to probe and to question you about your claimed damages. Now you might be wondering, wait a second, they're going to ask me about how often I have sex? They're going to ask me how many times a week, how many times a day I used to have sex before? The answer is, yes, they will. And you might be saying, wait a second, I'm embarrassed. I don't want to share that detail with anybody. This is private. Yes, it is private, except for the fact that the moment you claim that you now suffered these significant injuries and it has impaired your ability to have sexual relations with your spouse, the defense is entitled to learn details of your relationship, both before, during, and after. And if you fail to disclose that information because you are a private person, because you don't want to share those details, those intimate details with anybody, then guess what? Then the defense would rightly argue that they have no possible way to explore and determine whether or not that part of your claim is valid and has merit. So here's how this plays out. During the course of your deposition, the defense attorney will turn to you and say, Mr. Jones, before this incident happened, how many times did you and your spouse have sex? And you're like, I don't know, 3 times a week? Okay. And did you have any problem performing during those 3 times a week? No, I didn't. And for how long a period of time did you have sex with your wife 3 times a week? And now they're going to get into explicit details with you about your sexual relationship with your wife. And now, again, you've been told that you have to share this information if you are going to accurately claim that these injuries are preventing you from continuing your sexual relationship with your spouse. So now you begin to share that information. And then they go even deeper. They say, hey, Mr. Jones, as a result of this incident, how many times a week have you been able to have sex? Well, I haven't been able to at all. Okay, why not? And now they're going to get into exquisite detail about whether it's because of the positioning, whether you've tried different positions, whether you tried on top, whether you tried on bottom, and now they're going to get into really awkward and uncomfortable questions. And some attorneys actually apologize beforehand for beginning to ask you these questions. and they say, hey, Mr. Jones, I'm sorry, I'm going to be asking you a series of questions about your sexual relationship, and I'm sorry if this is intimate, but I need to ask it since you are claiming it in this lawsuit. They're trying to take an apologetic tone, but recognizing that they still have a job to do and ask you about these particular questions. So, do you have to answer these questions? If you are claiming that your sexual relationship was clearly affected and will affect you for the foreseeable future, then yes, you do have to go ahead and answer those questions. But now, here's a question that a lot of people ask, and they still don't know the answer to. Even if you go ahead and tell them all the details of your sexual relationship before, how is the defense going to actually verify that you were having sex 3 times a week for the past 15 years? Is there any way to verify it? The reality is no, there is no way to verify the sexual relationship you had in the past. How do they know that some weeks it wasn't twice a week or once a week, or that your wife was tired or that you were tired, whatever it is? There's no verifiable way to document, to verify that past history of your sexual relationship with your spouse. So now you're saying, okay, how are they going to know, or how are they going to verify that you have a problem now? That you have difficulty or limitations in performing sexually now? I'll tell you how. The defense is going to scour every single page of every one of your medical records for the records for treatment that you received after this incident occurred. And they are going to see if there's any reference whatsoever to your difficulty or inability to have sex with your spouse. If there is nothing, no mention whatsoever, at the time that these treatments are going on, at the time you are making significant complaints about problems you are having, now they will begin to question whether or not you have contradicted yourself. Do you really have a problem with your sexual relationship? Is this something that you are just trying to make up to increase and exaggerate the value of your case? So if there is no mention whatsoever in any of these medical records, the defense will ultimately turn around and say, I don't understand. You didn't complain to a single doctor out of 20 different doctors that you saw about one problem concerning your inability to have sexual relations with your spouse. Now, you may come back with an explanation saying, well, I was going to a different specialist. I didn't want to mention that to them at that time. Okay, you've now seen X number of doctors, X number of specialists. You're telling us that not a single one learned about these problems? Doesn't make sense. And they might be right. It might not make sense. And you may have to justify and explain away why you didn't share those details with any of your treating doctors. On the other hand, if there is information contained in your medical records that show not only the other complaints you were making, but also the difficulties you had with your spouse. Maybe you also had psychological and emotional issues. Now you're seeing a psychiatrist or psychologist to help you through them. And in addition, you might have other problems concerning your sexual relationship. Now, what happens though if in the past you also had a sexual relationship problem with your spouse for whatever reason? Maybe a prior injury, maybe psychological and emotional issues. How will that affect your particular claim for sexual relationships and your inability to perform and have a sexual relationship with your spouse now? Will it affect you? Will it affect that part of your claim because this occurred to you in the past? The answer is, it most certainly could. So why do I share this quick information with you? I share it with you because I want you to see in the background, I don't know if you could see it, but in the background there's a big tree and there are pelicans sitting in the tree, and it's fascinating. They're all lined up here all along the side of the beach. No, I realize you're not watching this for the pelicans or the scenery, but rather you have questions about your matter. Well, if you have not yet started a lawsuit and are thinking of doing so, and your matter happened in New York and have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a fantastic day.